Let's get started. Where is Sidnor? Is Senator Sidnor here? All right, Heather, we're going to start off with House Bill 107.
Hey, so House Bill 107. So this bill applies to co-ops, condos, and HOAs. So it's drafted to all three, either subtitle or title. So co-ops portion covers pages 2 through 5. Condos is on pages 5 through 8, and HOAs is page 8 to the end. So that's why the bill looks repetitive throughout. So the bill creates a timeline for completing a reserve study based on the existence of the community. So if the community is at this time does not exist when the bill goes into effect, the bill will state that the timeline for when the initial reserve study needs to be completed, and that the funds transferred from the developer to the condo needs to include those reserve funds. If it is a condo that is in effect before the effective date of the bill, it also states the deadlines for the initial reserve study to be completed, and the ongoing reserve studies, the updated reserve studies, needs to be done every 5 years. The bill also states the timeline for funding the reserves. So this is on page 6 of the bill, lines 1 through 4 for the condos. I was speaking with Senator West, and there's a proposed rewording of these lines to read that. The effect would be to give, if a condo does a initial reserve study, they'll have 3 years to fund the annual reserve, to reach the annual reserve funding level recommended by the initial reserve study. So I will read that out in the moment, the proposed amendment. The bill also alters the requirements for who can conduct these studies. And then lastly, it grants the Board of Directors the authority to increase the assessments to cover the funding amount required by the reserve studies. One difference to highlight is for the HOAs on page 9, lines 23 through 25. That's where you get the $10,000 amount. So that's only for HOAs, not the co-ops and condos. That's because the common elements of an HOA are different than co-ops and condos, which may include just a sign or something like that. So the total value for the elements needs to be at least $10,000 in order for them to be required to conduct a reserve study. And then for the amendment that that's just for HOAs. There is no number for condos. So the proposed change from Senator West be, if the most recent reserve study completed under 11-107.4, which is the section requiring the reserve study, the governing body shall, within 3 years following the fiscal year of the initial reserve study is completed, attain the annual reserve funding level recommended by the initial reserve study. So that's getting to the same intent of the bill, just rewording it for clarification purposes.
So the initial language was unclear and could have been read as requiring that if you have, for example, a 40-year roof replacement, that within 3 years you would have to fully fund the reserve for the roof replacement. This language, as amended, indicates what you need to fund within 3 years is 3 years worth of money in the reserve fund, which if you continue funding it for the full 40 years, you would have enough to replace the roof.
I did run this language by the sponsor, and he agreed with the language, the proposed amendment. That's what it is. So it's one amendment, but it would be made to all 3 portions.
You had mentioned something about $10,000 in HOAs. Where's that? Was that part of the
So
amendments you were talking about?
that is on page 9, line 23 through 25.
Okay.
So the full portion is this the requirement for the reserve studies only applies to an HOA that has the responsibility under its declaration for maintaining and repairing common areas, and for which the total initial purchase installation cost for all components identified, either the common areas and their components, is at least $10,000.
Thank you.
You're welcome.
That's the initial study, reserve study issue. That's on the top of page 9. Remember I brought that up yesterday?
Yeah, so, top of page 9.
Lines 3 through 4. Yeah. So from lines 3 through 6.
Oh, that's the HOA part for the same amendment that I just read.
Got it, but is it, did they address the issue of like whether it was the initial study or the last one you did?
So you have the 3 years to fund the initial reserve study, so then when you do the next reserve study 5 years later, that exception doesn't apply anymore because you've already built up that initial reserve, so your annual budget needs to be in compliance with the reserve study's recommendation.
Please. One is, can you read me the language again that talks about the amortization issue?
So, no, I've got another copy. Okay, so the general requirement is reserves for it in the annual budget shall be in the funding amount recommended by the most recent reserve study completed. And then it says, subject to this oral amendment. If the most recent reserve study completed is an initial reserve study, the governing body shall, within 3 fiscal years following the fiscal year the initial reserve study is completed, attain the annual reserve funding level recommended in the initial reserve study.
Obtain the annual.
Yeah, you still think that gets at it?
I thought you guys had your work group met on this.
I wasn't in part of it.
She wasn't there, it was us. We had that earlier. Oh, so read the last part again, Heather.
Attain the annual reserve funding level recommended in the initial reserve study.
The annual funding level. And if, in the case of a 40-year, a roof with a 40-year useful life, and it's gonna cost $40,000 to replace the roof, the funding level would be $1,000 a year. So the
I don't think this
annual
says
funding level recommended after 3 years would be $3,000.
I hear
in
what
the
you're
reserve.
saying. I don't think that says that to me.
Read it again.
Attain the annual reserve funding level recommended in the initial reserve study.
I don't think that's clear to me. No, I don't. Because it's like you want,
Clearer than what's there right now.
Where did that language come from?
Marvin presented. Somebody gave it to Marvin.
Yeah, so it's the individuals who conduct these types of reserve studies. So
They're clear.
I reworded it from there. So their original language was each community association shall within 3 years of the date of the reserve study attain the annual reserve funding level recommended in the most recent professionally prepared reserve study. So that was reworded to reflect the budget language that's elsewhere in that section, and that it's not every single time you do a reserve study, you get 3 years. It's the initial one to build up that initial reserve study basis. And then after that, every year you must comply.
so let me ask you this. So you do your initial one, and then 3 years or 5 years, right? 5 years, you have to do a new study? So you do a new study. Let's say you find out that you need a roof, a big expense on your first one, and it's a $40,000 roof, and you have $1,000 for the next 40 years that you're committing from that initial study. Let's say 5 years later, you need a whole new HVAC system, right? So you have this, what happens then? The same thing, right?
So you're asking what if in the second reserve study it finds something that the initial reserve study did not find? It would then incorporate that funding requirement for the new or whatever the new common element is that needs to be replaced. So if that common element needs to be replaced immediately, then the new reserve study will reflect the funding requirements for that
And
additional
then
change.
it will still be amortized over the
Relevant life.
yeah, its relevant life, and people will be assessed accordingly. I just want to make sure that the language we have takes care of each step along the way when they find new things. You
Yes.
think so?
I think so, yes.
Okay. Okay.
It seems like the scenario you're talking about would only happen if they built a new facility or something that was not captured in the initial assessment, right? And so you're assessing everything, and then 5 years later, you're assessing everything again. They're going to deteriorate over time, but I think what you were getting at is that, hey, we built a new basketball court that wasn't captured in the first one. Now, of course, the assessment is going to go up because you're adding more items, if that makes sense.
It seems to me there's always going to be something that is like extraordinary, right? Something that the cement fails in whatever had been built 10 years ago that wasn't captured in the initial. There's, so that's just kind of what I'm imagining, that they're going to be things that just come out of the blue. I just want to make sure that they're covered.
Oh, so Senator Hedelman, so every single assessment, it needs to cover all the common areas that are required under the bill. So your initial one is covering all the same exact common elements,
get it.
where the one in 5 years, if you didn't build any new additions, it's the same exact common elements. It is possible that they find a problem that wasn't discovered earlier because that's just the way things work.
Yeah.
So then the new, reserves would need to reflect the change for the new study that was completed. So the language that I read about the 3-year part, that only applies to the initial study. After that, it's the current law for Prince George's and Montgomery County where it needs to be provided for in the annual budget. So it's only a one-time 3-year option.
Oh, that was the question. So then you're just walloped for the other times. I'm not saying it's wrong, but
So let's do Senator Cassie's response, and then we'll go to Senator West.
So I shared the concerns about HOAs getting like, wow, where'd this come from? And so then I reviewed with council. So what happens if this comes back and the HOA just says, can't do it? So then it goes to, the AG's office does mediation to try to come to a resolution. If the resolution fails, then it goes to the court, at which time the court has the ability to say, you can't do this, we'll set up a schedule over 10 years or 15 years, because you can't. There's 2 levels of, well, really 3, because the first level is HOA works it out, then in the court, then the AG steps in and mediates, and then if it's still not worked out through mediation, and in mediation, they could agree to stretch this, and then you don't get any mediation, so now you go to the court, and I have another opportunity for the court to step in and say, these people all make $60,000 a year, they cannot do this in 3 years. Let's structure something here that will work, we'll do this on a payment scale or something. So I felt, because I was really, my whole concern with the whole bill was that it could just be an unworkable mess that a particular HOA just could not live with. So I think with those different levels, I feel more comfortable that we have some discretion of minds to say, let's come to something that works for these people in this particular condo, which may not be affordable to them.
don't get me wrong, I mean, safety concerns and structural issues, of course, people, and you have to pay for that. I understand and I support that, but I also am concerned about people having the ability to be able to pay over a period of time. That's my only concern.
Senator West and Senator.
I'm not sure I really need to spend much time. I'm responding to something that Senator Hedelman said a few minutes ago, and that is that each of these studies has to study all the common elements of the building. So we were talking about the roof, but that's not only the subject of the study. The boiler is going to be a separate study, et cetera. So the study will contain all these various components, each of which has a charge associated with it, and the charge gets charged each year. And presumably, if they follow the guidelines of the reserve study, when the boiler gives out in 20 years, there'll be enough money to replace that. And when the roof has to be replaced in 40 years, there'll be enough to replace that.
Thank you. Few questions. Initially, I was wondering what happens if the organizations don't comply. And then I was hearing what Senator Castley was saying, but I don't recall seeing any of that in the bill about someone going to court and the AG.
It's all separate, it's the existing law.
Okay,
That's in council, that's
Gotcha.
existing law, not part of this.
got you. Now, secondly, with regards to notice, I don't recall, I mean, did you all talk about notice to these HOAs? Because most of them, they're volunteers and could have absolutely no idea what their responsibilities are. I mean, that's been my experience in dealing with HOAs. Notice regarding their responsibility to even do this. Somehow, these organizations, they're going to have to know that this is a requirement.
The bill does not contain a notice requirement to the HOA. So a condo, it's not run by all the individual unit owners. They are the council. They elect the board of directors, and the board of directors is the one who would be, they exercise the powers of the council. So they would be the ones responsible for doing this.
All right, so I mean, I'm thinking, I mean,
I would,
some HOAs, I think they
Yeah.
I don't know if they registered the
it would have to
Secretary
be
of
someone
State.
would need to raise the issue to them saying you need to comply with this. It could be someone on, one of the unit owners raising the issue that this needs to be done. And if it's not done at that time and the board of directors refuses, that's when you'd have what Senator Castley mentioned. You could go to the OAG's office saying that your board of directors is now refusing after you've raised the issue. They're not complying with it.
Gotcha. And the third thing that I just wanted to ask, if you all talked about on page 11, lines 13 and 14, it talks about the person who's preparing the reserve study having to have prepared 30 reserve studies within the prior 3 calendar years. I mean, that may have been good for Prince George's County, but you're talking the entire state of Maryland, and I'm wondering what kind of market may be available to even help to do these studies.
Yeah, so I talked to committee counsel in, I think it was E&T, about that proposed amendment. The reason why the bachelor's degree was struck is because to hold a license for the State Board of Architects, these are some of the requirements that the individual would already need to meet. The,
Oh, no,
or not necessarily.
Yeah, I didn't see the thing about the
Are
bachelor's
you talking about
degree.
the proposed lines 15 through 18?
13 through 14, I mean, it's already
13 through
current, it's
14.
already
Oh,
current law.
okay.
It's current law, I guess.
So that would be current law.
Right, do we have
How
enough
many-
people who can help do these
Yeah.
things?
At least it's for 24 jurisdictions as opposed to
Right now that
2,
we're
or
making it
you're
statewide, I wasn't certain if it came up in conversation.
Oh, my understanding is that the language is to provide flexibility so that more individuals would be able to do this based on experience, not credentials. I understand that's not the lines that you're looking at.
Mark Delegate Holmes, is there enough people out here that can do this?
Oh, okay, I didn't know he was here.
24 jurisdictions, are enough people to perform these studies?
Yes.
We have enough?
Yes.
Okay, thank you, that's all I want.
Yes.
Okay, thank you very much, Delegate. All right. He's watching. You got bills in ENT? Adopt the amendments? Yes. All right, so seconded, it's moved, all right. Further discussion on the bill? Favorable. It's been seconded, everyone's okay? Awesome. Thank you, Delegate Holmes. Thank you. All right, have a good one. That was good yesterday. All right,
We go sit in on ENT, which is all good.
yeah.
While they vote on bills.
Party at ENT with drinks. All right. Coffee, that is, and water. All right. Now let's go to House Bill 157.
House Bill 157 is identical to Senate Bill 146, which has already passed the Senate. The bill prohibits stopping, standing, or parking a vehicle in a designated plug-in electric drive vehicle charging space unless that vehicle is a plug-in electric drive vehicle that is plugged into the charging equipment. The bill establishes signage requirements for such spaces and establishes that a person who violates the bill is subject to a civil penalty of $100.
All right, is everyone okay? All right, excellent. Yes.
House Bill 813 requires Montgomery County to annually submit reports related to school bus monitoring cameras. Additionally, the bill requires the county, in coordination with MDOT, to examine data relating to school bus stop violations and to implement certain measures in response.
That's, all right. 813 is favorable, so now we'll move on to Montgomery County delegation, House Bill 231.
House Bill 231 authorizes Montgomery County to designate the County Department of Transportation in lieu of the Police Department to implement the county's automated traffic enforcement. The parameters would essentially be the same as those that exist for law enforcement agencies under current law.
I don't like this one. When they originally brought in all the, red light cameras, speed cameras, they said, oh, don't worry, we're gonna have a police officer. He's gonna be looking over every part of it. This isn't just gonna be a system where it finds you and you automatically get sent it. Even though a police officer's not actually citing you, which people were upset about, they're like, we're gonna have a police officer looking over this. Well, now this takes it out and just has, just some bureaucrat send the fine over. Like the whole argument in favor of the automated enforcement for years was there's a police officer that actually looks at it, makes a determination, then it's sent over. If that actually happens or not, I don't know. But now we've broken down to the point where it is, literally the picture's taken and it gets sent to you.
I hear you. It's funny, I thought that, Josh, were there amendments that were offered? Did Gaithersburg? I thought I remember.
Yeah, the mayor of Gaithersburg did submit testimony. They had some concerns about how this interacts with the municipal cameras that they operate.
Former hometown of Gaithersburg.
There you go.
I won't hold that.
All right. Well, let's hold this until we'll loop back with Gaithersburg, and we'll get back. So hold this for the session. Yeah, so let's go for 615 and then we'll do 616.
Okay, so Senate Bill 615 is on condos and HOAs. So House Bill 615. So this alters the current dispute settlement process. So this is going over the condo process. So the council or board must provide, instead of serve, a written cease and desist letter and give the unit owner not less than 10 or 15 days instead of 10 days to abate the alleged violation. So if the violation reoccurs within 12 months after the demand, the council must provide, instead of serve, a written notice to the alleged violator's right to request a hearing. So if the alleged violator requests a hearing, the hearing may not be held less than 10 days after they make the request. And if no hearing is requested, the board will discuss the matter at the next meeting and reach a decision then. The current law does not contain a dispute settlement process for HOAs, so it creates the condo amended process. It adds that to HOA, the title for HOAs. So if you're looking at the bill, section 11-113 is the condo part. And then on page 4, 11B, title 11B, that's the HOA part.
That must be good then.
There was no opposition, well, there was no opposition.
There's no opposition. And there's no proposed amendments.
Which pleasure, the motion for?
So motion for favorable. All right. Is everyone good? All right. Let's go to House Bill 616.
So House Bill 616 is very similar to 615, but it deals with co-ops. So it does the exact same thing, it does the same changes that the condo bill does to amend the current process for dispute settlements for co-ops. But then on page 4, it repeals lines 16 through 29. And this is the part that says that the dispute settlement part, you can't use the dispute settlement part for failure to pay assessments, which is rent for co-ops. So you'd have to go through the landlord-tenant process to evict a unit owner. Or, excuse me, not a unit owner, that's condos, a member, to evict a member, you'd have to use the landlord-tenant. So currently, before you can file for, under the landlord-tenant law, you have to wait 3 months of the individual delinquent and paying assessments, and then file landlord-tenant law.
So this bill looks like you didn't have to wait 3 months?
Yes.
So I do have a question about that. So co-ops are, you're talking about when people buy into co-ops, they're purchasers just like a homeowner or a condo owner, except for it's a co-op, so they have to pay these fees, right? In addition to their monthly payment.
A co-op is more of like, so it's defined as.
But still, it's not like a tenant because they're buying into, it's an investment into ownership. So, but
Yeah.
you're not, but we're not talking about,
Prior
you
to
didn't make your monthly payment for the property. You're talking about the condo, the equivalent of a condo fee.
As to the stockholders.
Right, so it's like the equivalent, it's analogous to the condo fee.
Yes. And we have very few co-ops in Maryland.
I know, I used to live in one, so that's how I know. But so that's a little bit of the question I have. Definitely don't encourage people not paying their co-op fees, but it's not as if they're not investing in the property. It would seem to me a reasonable wait period would be okay. What's the urgency for why we don't want to even give them more than a regular tenant?
The testimony that was submitted to the committee, written testimony, is just saying that the current landlord-tenant law already offers enough sufficient protection to the individuals, and the additional 3-month is an additional burden in the process.
So I'm not sure it's really that much of a burden. Think about it. If you just equate it to a condo or something else that you're purchasing, and then you just, so you've either already paid for to own the unit, or you're making mortgage payments, or payments, not mortgage payments, but, you know, in payments to someone else that previously was the owner. so you're not falling short on that. You're falling short on the additional thing that's either like the co-op fee, or if you live in a homeowners association, that fee. But we don't say in those situations that a person should be treated like a tenant and that they should immediately be able to be evicted. I don't see this as the same thing.
Yeah, this provision was adopted in 2014. So prior to 2014, they followed the landlord-tenant process for evicting, and did not contain the 3 months or more.
So we changed it from that for a reason, right? In 2014, it was that, and then we changed it? Is that what you're saying?
I wasn't here in 2014,
Okay, but
so
I'm
I
saying-
don't know what the arguments were then.
I mean, I think these are legitimate questions, and I'd love to hear the counter argument for why this is good policy.
Hold it, hold it.
Why is it good policy? Other than it's the,
The only recommendation I would have.
they are more similar to landlord-tenant than they are to a condo.
But the landlord-tenant law applies, so that they would have to do a double process.
So but it's still not exactly the same. Again, tenants are like, month to month or whatever, or year, whatever. They don't plan to have any ownership when they're done. When they're evicted, it's over for them. But these people are buying into something, and I don't understand why we would say that they're equated to a tenant.
They would have to go through it would be two processes. The second one should not apply, the one that's in the bill right now, where, I don't have the bill in front of me.
So if you've purchased like a $200,000 co-op, and you've spent your $200,000 and you've been living there for 5 years, and then for whatever reason, illness, neglect, whatever, you miss your co-op fee for a month, you could be evicted? That just doesn't seem reasonable.
You would go through the same landlord-tenant process that a tenant would, which is much longer than the condo HOA process with collecting assessments.
We're gonna hold this for a day. So in the interim, let's get Jill, Chris, Watson, since you're the housing people, and you guys, can you just sit down with Lisa? If there's something to be figured out, we'll figure it out, and then if not, that's that. Okay, let's go to House Bill, Heather, so I'll stick with you, House Bill 40.
Oh, Lord, more condos.
It's the last condo
These need
one.
cross files. Cross file these complicated condo bills, please.
Okay.
All these local condo, please cross file it.
Okay, so for this bill, just to give you,
These people love to pass bills. Susan would love to take them next year, or Chris.
Now that you're leaving, you're like, hey.
But I'm giving you all some free advice. They both carry 30 bills a year. They'd love to add another 10 on to pass. They will take these, they'll pass them, your lives, everyone's lives will be better. my free advice. These are too complicated to come in the end. It's funny because it's true, but.
Okay, so with this bill, we're only talking about condos. So to give you some background definitions real quick, so you know what I'm talking about. Council of unit owners are all the unit owners. They govern the affairs of the condo. The board of directors are the persons who are elected by the council to exercise the council's powers. And then the warranties that are discussed in this bill are the warranties that apply to the sale of every single property, that at the time of completion, the building or improvements are free from faulty materials, constructed according to sound engineering standards, it's fit for habitation, and then also it has additional condo warranties as to the common elements from a developer, so it applies to the roof, foundations, external supporting walls, mechanical, electrical, plumbing systems, and then the common elements is every single part of the condo except for the units. Okay. So then the bill provides that it prohibits a council of unit owners from entering into any agreement that settles or releases a council of unit owners' claims related to the warranties that I just went over. So if a contract for sale, either at the initial sale or resale of a unit, does not contain a certain notice about whether these warranties have been waived, then the contract for sale is unenforceable by the seller. The bill also requires the board of directors to disclose to the council any agreements that they're going to enter that would waive these warranties 21 days before entering into the agreement, and also any non-disclosure provision that would prohibit the board from disclosing this information to the council. It's unenforceable. You can't do that. So in short, the bill prohibits the non-disclosure agreements that waive these warranties to council owners and requires the agreements that waive these warranties to be disclosed. So there are no proposed amendments.
I'll buy a drink for any senator that can explain what that bill does, please. Please. A drink on me. Who can do it?
Yeah, I mean, so you're moving into one of these things and you review all the disclosures about warranties and defects and everything, but what's not told to you is that there's already an agreement out there waiving some of these warranty requirements, that they've already signed, the council's already signed an agreement with the warranty, regard those warranties that we don't know about. So to me, this is just basically, yeah, it's a transparency, transparency provision. I don't have any problem with this. I think it makes sense because there's so oftentimes the board are people who are living there, and now you get a new owner coming in, and they're not apprised of and they're at risk. So I don't.
There's no opposition. Second.
All right. All right. This feels good.
Cassidy's summary was correct.
Cassidy's summary was spot on. We found a floor leader, so, all right. The first round on us, man. All right. Everyone's okay?
So House Bill 78, this bill prohibits an employer from failing or refusing to make reasonable accommodations or to the known disability of an applicant for employment. This requirement does not apply if the accommodation would require an undue hardship on the conduct of the employer's business. If you look at the committee testimony, the amendments that were proposed have already been incorporated by the House, so they've already been adopted. And then also Maryland, the commission states that this reflects the current practice, but is clarifying. No. So the testimony said favorable with amendment, that if you look at the floor system, but those amendments were already adopted by the House, so it's just favorable would be the motion. Those have already been adopted. The amendments, the applicant had to be a qualified applicant, which would have required an additional hurdle for the applicant. That's what the whole purpose of an interview and application process is, to determine if the applicant is qualified.
So currently, you employ somebody with a disability, you have to make reasonable accommodations. I get that they're in a wheelchair, they can't sit at a desk. You gotta get them a desk that is equipped for a wheelchair, something like that, or, those sorts of, so the person can get a job, so that makes sense. But then, now we're extending this to not just a person you hire or would be hiring, but it's an applicant. How do you accommodate an applicant's, is this saying that, oh, you couldn't get in the interview room? What, I'm not understanding the applicant's. Why would you extend this? If I never hired you, why would I accommodate you? I don't need to accommodate you if I don't hire you. If I didn't hire you because you were disabled, then I got a problem because I should have done that. So I don't understand the.
Oh, so it's my understanding that some job interviews require a test of skills. Not all of them, and I thought like you did, I'm going into a room and I may have a disability, so the building has to be outfitted to accommodate me coming in for an interview when I may or may not get hired. It's my understanding that there are some circumstances where an applicant is coming in to undergo some kind of preliminary test or some kind of show of skills, and that is what needs to be accommodated, is my understanding.
I thought, like, Glendora Hughes from the Civil Rights Committee, if you look at her testimony, I thought that, because I think this came up during the hearing. Yeah, this came up during the hearing. I mean, this is what they do already anyway, and this is how they're interpreting the statute. This is just, in their interpretation, this is just clarifying and probably codifying the existing practice, or, I mean, more clarification than anything, because they already do this. They're already interpreting the statute to include this. But if you look at the second two paragraphs on the first page, at the bottom two paragraphs on the first page, I thought that was pretty informative. Commission on Civil Rights testimony, sorry. Yeah, yes. Any further discussion, or I just want to make sure we're all good? Okay, so it's been second, all right, everyone's good. All right. All right, you know what, let's do, what did I say? This is House Bill 222. Now, Senator Sidnor, I remember during the original hearing when Senator Edwards had the cross-file for this, you brought up some concerns, but just want to request to put this on. House Bill 222. Just want to put this up for a little bit of discussion, and then if there's still unreadiness, then we'll hold it.
So House Bill 222 requires on an interstate highway located in a rural area that a driver traveling slower than the general speed of traffic drive in the right-hand lane, if practicable as determined by the driver. So the bill establishes that this is the policy of the state, but that a person may not be issued a citation for a violation. So that's specifically the piece that was amended in by the House. The MVA would have to include the requirement in the driver's ed curriculum, and the State Highway Administration must inform drivers of the requirement by placing and maintaining signs at regular intervals on appropriate highways.
So, I thought this was already like, though, we used to have this bill every year and it wouldn't pass or whatever, that would make it a ticketable offense, and actually this committee didn't want to move it forward. I did, but the other people did in the past. Well, isn't this right now, though, it's like a rule of the road, or it's just like an informal rule of the road right now?
I don't believe there's anything formal in the
It's
code. I
not.
might have to go and check that, but
I mean, so out by me, I live in a little town, Brunswick, and you get from Brunswick on one side of Frederick County to the city of Frederick. It's 340 is the road. It's a 2-lane road. Oh my God, it's so annoying. These people that are in the, I was always taught the left-hand lane is the passing lane, the right-hand lane is where you're driving in. Apparently, they stopped teaching that because there's a lot of people that just drive slow as heck in the left-hand lane. So this bill is basically saying slower traffic, keep right, is you're gonna have signs up saying that, right?
Correct.
That's a great bill. I thought we already had some of those up in places in Maryland. This is just, all it's gonna do is tell them to put signs up. If this helps them put signs up, I'm fine by that.
If I remember correctly, one of the things that council had mentioned was that one could, I think, once you looked at the fuller body of the statutes, people could be fined. Was it just fines, or was it, it wasn't an arrestable offense, it was just fines, right?
Yeah, so the way it was drafted, it would be subject to the general misdemeanor traffic penalty of up to $500.
Can get fined for being slow in the lane.
So there is,
Which is fine by me.
there is currently law, it's section 21301 of the transportation article. It does say on every roadway that is wide enough, a vehicle shall be driven on the right half of the roadway except, and there's a number of exceptions, including on a roadway that is divided into 3 or more clearly marked lanes, subject to the rules applicable to those roadways. So there is a requirement, but there's a lot of exceptions to it.
And what I had made, I think at the time when the bill came up, I had referenced back when a number of us were in the House of Delegates, how the vote on this bill was really crazy because you had Republicans and Democrats on both sides.
It was Bill Folden's bill. I remember, yeah.
Exactly. And I recall writing an op-ed because I experienced something like this, not here in the state of Maryland, but in Virginia, where I was pulled over by an officer who said I was driving too slow, when in fact what I was doing was I was on vacation trying to figure out what the speed limit was, and I misread the speed sign, which I think, and looking back in retrospect, I think it was a 45 during regular times, but 30 or something, and I may have the numbers wrong, during school days. Well, I saw the 30, so I started driving the slower speed limit, which was why he pulled me over. And the issue with being pulled over for something like that was, again, you've now created a situation where this officer was extremely discourteous to me in front of my wife and in front of my children. And it left me feeling it upset me, messed up my whole vacation. So again, the question is, if this was just some sort of bill where we're just telling people, look, move over, drive, you're going to drive the speed limit, because it's not driving slow, it's driving the speed limit in the right lane, or stay right, then that's one thing. But again, if we're...
Well, I actually look at this, and I don't know what's being done now, because I will say I don't think it works. Like when I learned to drive, they basically taught me the right hand is for driving, the left hand is only for passing. And I know in other states, like out west, they were militant about it. Like if you were just driving up on the left-hand lane and you weren't passing people, they would pull you over for that. They were like, that left-hand lane is for passing. And when you get out in real rural country parts, like out in Colorado and stuff, they were pretty tough about it because you could mess up traffic flow on a long road that way. But it does have something in here, the administration shall include the requirement of this in the state driver's education curriculum. So the way I read this, Josh, unless I have it wrong, this is just basically educating people about it and putting up more signs is the outcome, unless I'm missing, because I'm reading the current law, it seems to cover a lot of this. This just seems a way to force signage and education.
Right. With the way the bill came in, unamended, it would have been a violation which you could be pulled over and cited for, but the House amendments took that out, and now it basically says it's the policy, put it in the curriculum, and there have to be signs installed in the appropriate locations.
Specifically says a person may not be issued a citation for a violation.
That's my question. Just because you can't be issued a citation for a violation, can you still be pulled over for it?
I don't believe so, because there would be no
It's still a
cause
violation
to
of the
pull you
law,
over.
So let's get the.
So, anytime that you are driving up and down the highway, and an officer feels that there is some unsafe activity that you're creating, let's say you were in the left-hand lane going 40 miles an hour, and everybody's passing you in the right going 65, right? he can clearly pull you over, right? Make sure there's not some medical incident going on with you and why you're not there. But, what's that? That's exactly right. But, I mean, the reality of this, having, and I don't know how many other people have a child that just learned to drive in their house, but after we heard this and with these amendments, I think this is a great idea, right? I think this really does help when we take them out on the main road and we get them out there and they're driving along, they can be in the right lane and they're not worried about it, right? Because on a dual lane highway in our regular areas, you don't have to, Maryland doesn't have the law like so many other people. This would be a good education to put in there. I think I'd move favorable on the bill.
Did you say without the citation, there's no reason for the police officer to pull you over? Or the officers can't pull you over?
They could not pull you over for a violation of this provision if they could, plausibly argue that it was negligent driving or reckless driving. I mean, those are obviously things that you could be pulled over for. So they couldn't pull you over and basically say, I pulled him over because he was violating whichever provision this is, and because that,
So
they would
can
have no cause to stop them.
It's currently a penalty.
Yeah, that's, I guess,
They're actually decriminalizing.
just because you can't, you're probably right, Mike, but just because you can't be cited doesn't mean you can't be pulled over.
Yeah, because it says a violation is a misdemeanor subject to a maximum fine of $500. That's the current law. Upon a conviction, MVA must assess a point against driver's license. So this is already the law. I guess what they're trying to do is just get more, they're trying to force, they're trying to force the administration to teach about it in the curriculum and put signage up. Clearly, it's not enforced.
So what's currently in the law is, if you go to the third reader of the House bill, page 2, lines 13 through 19 is kind of a more specific prohibition. So it's except while overtaking and passing or going in the same direction, preparing for a left turn, any vehicle going 10 miles or more below the speed limit, or if any conditions
Oh,
require.
I
So
got
it's a little bit more of it's a more specific prohibition that currently carries a penalty.
Versus driving in the right-hand lane, or driving in the left-hand lane. That's all it does anymore. That's all it does anymore. No, there's no citation anymore.
I don't know that I completely agree that you couldn't pull somebody over for it, even though there's no citation. Basically, the criteria for being able to pull somebody over is that you have reasonable suspicion to believe that they're violating the motor vehicle law. This is still a violation of the motor vehicle law. It's just that there's no consequence for violating it. So maybe, but if
You
the
can still be pulled over if your question is the interaction between the law, a reason to pull someone over.
And if I'm not understanding what I'm hearing correctly, law enforcement could already pull you over for this.
No, I guess it's 10 miles. So you'll be driving 10 miles slower than the state limit, right, Josh?
Yeah, it's a little bit more, for this particular section, it's a more specific prohibition right now, and this would apply in rural areas only. And it would be, instead of saying it's specifically 10 miles below, it's you're traveling less than the general flow of traffic.
I mean, what you're trying to prevent is two cars riding side by side.
Right.
And stopping. I mean, we've obviously not gone to left-hand only, or left lane is only for passing. I wish we would, though. I mean, it's just out in my area, it's just a huge problem. It just jams up traffic, because people don't understand that. And I think this is a pretty smart way to get at it. If you're not trying to criminalize it, you're just trying to get people to understand that that right lane is for driving, left is for passing, is what you're trying to do without making it criminal. So I know I know why he's bringing it in. He's Washington County, which is right next to me, and they have the same problem.
Right.
Is everyone okay with that? Is everyone okay?
So it's favorable
Favorable then, all right.
and similar.
Hold on, let's go to,
Why don't you do the Senate version?
the Senate version. Which one is that? Senate Bill what?
Senate Bill 416.
All right. Second, same recorded vote?
Well, were there
were there amendments
amendments to
with
the House
that?
version? Do we need to conform it?
have to amend it to conform it to the House version.
All right, so the motion is then, got it. Everyone's okay.
Does Senator Sidnor, do you want to be in support of the amendment for the Senate bill?
Support the amendment down with the bill. Yeah. All right, Josh, let's stay with you and we'll do the, oh, hold on.
You just said 210.
Sorry, did I say 210?
Yeah.
Is that you? Yep. All right, let's see how folks feel about this one. House Bill 210.
So House Bill 210 establishes that the spouse of a person on trial for a crime may be compelled to testify as an adverse witness if the person on trial and the spouse married after the date on which the alleged crime for which the person is on trial occurred.
It's not, it's just to get.
So just some commentary from the Maryland Evidence Handbook from Lexis. In Wilson versus State, the Court of Special Appeals reversed convictions for witness tampering and obstruction of justice and expressly declined to create a judicial exception to the spousal privilege. And hold that a spouse may invoke the privilege even in the context of a sham marriage. The Court of Appeals has granted cert petition which asks whether a party to a collusive marriage can invoke the privilege and whether the state can introduce evidence of the defendant's spouse's conduct in arranging the marriage. So that's currently unsettled.
I mean, for God's sake.
This was a great, there was like a whole season of The Sopranos dedicated to this.
And what happened to it? Because I thought we got rid of it.
I think it might have been the COVID session.
So this is only a House bill?
Yes. Yeah, why don't these guys show us any love? It was an easy.
Grammer's bill?
Yeah,
That's all I did was solid.
yeah, we're good.
I hate that whole everybody okay. I've missed too many bills like that, but I'm okay.
House Bill 679 expands the definition of vehicle salesman to include any individual who, for a commission or compensation, negotiates with any person to enter into a financial security, insurance, or warranty agreement. So this would have the effect of requiring those people to be licensed by the MVA. There is an amendment, it's not in your packet, but I will describe it orally. It kind of changes exactly who is covered by the bill. So on page 2 of the bill, from lines 9 to 12 in that new language. So it would read, with the amendment, it would read, for a commission or other compensation, negotiates with or induces any other person to enter into a financial security or warranty agreement on behalf of a dealer in connection with the sale of a vehicle. So basically what the amendment is doing is getting rid of the language that it's under any form of an agreement or arrangement with the dealer and replacing that with it's on behalf of a dealer in connection with the sale of a vehicle, and it's removing insurance. So someone who just sells insurance would no longer be covered by the bill.
So I support this bill. It's a good bill, and I think we should pass it. I just want to make sure this gets on the record. So the amendment that you just offered on page 2, line 11, strikes the word insurance.
Correct.
Okay. And my understanding is that the advocates behind the bill are supportive of that.
It does also change some of the other wording. So it's striking the phrase under any form of agreement or arrangement with a dealer, and instead replacing that at the end of the item with on behalf of a dealer in connection with the sale of a vehicle. So it's sort of changing the verbiage about they're not under an agreement with a dealer, rather they're acting on behalf of a dealer.
Why do we care what the definition of vehicle salesman is? In what way is that definition used?
So being a vehicle salesman requires you to be licensed by the MVA.
You have to be licensed as a used car salesman? Ha, really? Okay. Well, that makes sense, but I wasn't aware you had to be licensed as a used car salesman.
People are making bad deals and getting, what's the problem?
I don't know, the consumer advocate, it made sense. Yeah, the consumer advocate people came in, it just made sense to me, because if you have to license the dealers, a lot of times you actually do, a lot, some of the negotiation, that part with the person that actually does the auto loan back there, they're involved with the sale too. they actually the ones that sign off, and they're part of the sale as well. So I just thought it was common sense to throw them in. And I think everybody wants this. The dealers want it, the consumer people want it, so it was,
Oh, okay.
yeah,
Everybody wants.
yeah.
Shall we have much further here to do all our agreement letter?
Let me see. Yeah, it would be one amendment.
Good, not everyone's good, but favorable. All right. All right, motions for favorable. It's been seconded. Everyone is good. All right, let's see what people think about House Bill 303.
Okay, where is this?
This is the International Pool Standards Bill, very important.
So, House Bill 303 requires the Maryland Department of Labor to adopt by regulation the International Swimming Pool and Spa Code after review and consultation with the Maryland Department of Health and with appropriate modifications as specified in the bill. These standards adopted apply to each swimming pool and spa in the state for which an application for a permit is received by a local jurisdiction on or after June 1st, 2023. The bill establishes other related responsibilities for the Department of Labor and each local jurisdiction, including that the Department of Labor maintain an informational database with specified information about the pool and spa standards and electrical code standards used in the state. The Department of Labor must provide local jurisdictions with the hardware and software necessary to access the database.
Spas, correct?
No.
Then that's not what the international, that's not what the International Swimming Pool and Spa Code state. I'm looking at the language, and it's talking about public spas, public exercise spas, public swimming pools. So I don't think this applies to a hot tub that I have in my backyard or my own private pool. Can somebody check that?
Well, that was sort of along my same, I know throughout the state, we have different electrical codes, and you are regulated differently. And I know currently having a pool in the backyard that went through, and,
I know.
well, we might have to have one.
Throw that detail out here.
So the issue is this, that we go through a very rigorous inspection process in the county, but it's like anything else, when we add the state in to another issue, it's already difficult enough to deal with what each county has to deal with. I'm not in favor of this.
The only thing is, it's, so my thing is, so we actually killed this thing like 2 or 3 years ago, because I didn't see the need up for it, but at this point now, I've only had pool people come in and ask me to vote for the thing. I think most of our counties already have it or want the thing. I haven't heard any opposition to it, so that's why I was actually more,
You know who'd be opposed? It's people who have pools.
Like
Who've
that?
had a pool for 10 years, 20 years.
isn't this just building of new pools though? This is going forward, isn't it?
It only applies to new construction. It's a building code bill. So it treats
applies to new construction?
new constructions, and like if you make a huge renovation that requires you to get a new permit at the county level, you might have to build up to it. But it's not, like, it has nothing to do with a current pool. So if you have a pool in your backyard and you're not doing anything with it, this bill has nothing to do with you. It's just a building code bill, and it treats swimming pools the same way we treat other building industries. So just like the International Building Code, the International Residential Code, it's the same group, the International Code Council.
It doesn't say that, does it?
Yeah, look at the very bottom.
Oh.
Look at the very, very bottom.
Very bottom, okay. Oh. That's way down.
So I'm just a little confused because I thought like on the international building codes, all the other codes, each county adopts those. I wasn't aware that the state adopts those because the county enforces those. Does the state adopt the international building code?
Yes, so every 3 years, the Department of Labor, where I used to work, adopts the building codes, and then they make changes to it as they see it. They send it to the counties. The counties can make changes. And if the county code conflicts with the state code, the county code wins out because the county enforces it. This is be the same process.
No, it's not, because this says that the county code can't be less than the state code.
Right, no,
That's what this bill says.
hold on.
That's the whole point of you saying state standard. So like, the other thing I asked these guys, and maybe Grace can answer, I asked how many other states have it, and it was like, well,
It's a lot,
it
yeah.
was like 30 or 40 states too.
And I don't know if there's that many, but every jurisdiction that surrounds Maryland has it except for the state of Delaware. So, and Georgia has it, Texas just recently adopted it, New Jersey has it.
I mean, trust me, I was not predisposed to pass the thing, but I can't find any opposition. Everybody else around us has it. I'm struggling to find a reason to vote no.
As long as it exempts existing pools, I'm fine with
Which
it.
is,
Just give you an example, there need to be diving board standards, so if you have the diving board, pool sides have to be far enough away from the diving board that someone who goes off the diving board stupidly doesn't crack his head on the side of the pool. See what I'm saying?
Yeah.
There's an amendment that,
Sort of to what Senator West was talking about, it,
Renovation that results in substantial or material structural change to the pool or spa.
right. So,
no, but as we was talking about, I understand that there's some sort of an amendment that would address Cassie's concern. Is that accurate?
You get Cassie.
Yeah, I'm not hearing anything, I'm not understanding, I mean, having worked in county level government, I know we adopted the fire codes, the building codes at each county level. And I thought we had flexibility to make changes in those. This seems like we're doing a different thing for pools where you couldn't reduce the standards in the state code. But you're telling me that the state adopts all those codes as well? And
yes, the Department of Labor adopts International Building Code, International Residential Code, yeah.
and then the counties, they adopt it as well, and they, as their own county code, and then they can amend it. But this one seems more restrictive, that you can't. Maybe it's not, maybe the counties can't reduce the standards, maybe only the counties can increase the standards on the other ones?
if you look at page 4 of the bill, Senator,
What's the bill number again?
it's House Bill 303.
Yeah, thanks. We lost it.
So page 4, there's a section 12-1204 that provides a local jurisdiction may adopt local amendments to the standards if the local amendments do not, one, prohibit the minimum implementation and enforcement activities set forth in 12-1205, or weaken energy conservation and efficiency provisions contained in the standards. So that's essentially what this does is says that the state standards are the floor. The local jurisdictions can adopt amendments to that as long as it doesn't fit into either of those two criteria in lines 19 and 21.
Okay. All right, as long as we're treating it the same as the other building codes, I guess I'm all right.
Yeah, it's, Senator, so,
That is that it's all pools.
So it's my understanding from Grayson that this applies to new pools built after a certain date. Based on the International Swimming Pool and Spa Code, there's a provision in there for maintenance adhering to the code. My question is, if I get a new house and get a pool, is there a new requirement levied on me as the owner in my own backyard that I have to follow this standard for maintenance?
I guess like, sort of the example of that would be, what would happen if like you have one type of drain that was totally fine to have on that pool
Depends on how you,
before?
it depends on how you're defining maintenance. So,
Right.
of course, you're looking at big stuff. I grew up, we put the little spider thing in there to get the algae out and all. I don't know if that was according to the standard or not. But if
Right.
I, as a individual homeowner, have a pool and I have to go to some new standard, is that a certain level of expertise person that needs to come to my house and perform maintenance, or can I just go to Home Depot and do what I used to do? That I don't know. I'm asking.
My understanding is you would just be able to go to Home Depot to do what you need to do unless the county required you to. And most of the stuff they sell at Home Depot is already gonna comply with this code. Because I mentioned the other states have it. So it's not like, I mean, if you created your own pool motor, I guess, out of scratch,
Can't do that.
maybe you can't do that, I don't know.
Right.
But like most of the stuff you buy at Home Depot is gonna comply.
Okay. All right.
That's my,
So
All right.
to your question.
That makes sense to me.
the adoption, I guess on a more technical perspective, the adoption in section 12.1203 says that the department adopts by regulation the international code with modifications incorporated by the department. And those are in B. So just sort of running through that, before adopting each version of the standards, the department shall review the International Pool and Spa Code to determine whether modifications should be incorporated in the standards, consider changes to the International Swimming Pool and Spa Code to enhance energy conservation, adopt modifications to the standards. I'm trying to see if there's anything in there about where it conflicts, because obviously the statute is saying that it applies to those new constructions and major renovations. But if the code itself has provisions that talk about, well, whenever you're just doing maintenance, like what applies, that would seem to sort of conflict with what the state law is saying if the code just has something contrary. So, yeah, I don't think it really speaks to it specifically, but, right.
All right, there's a motion for, okay, there's a motion for favorable, it's been seconded, we'll do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee. Yes. Senator Casserly.
Yes?
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Carter. Oh,
It already passed, man. You're
Yes.
so worried over there.
Senator Huff.
Yes.
Chairman Smith.
Yes. All right, we do,
So we need to, I think, adopt the House version,
Right now,
conform to the House version.
Can you-
Right,
can you-
Jamie?
can you
So the Senate version is Senate Bill 3. The Senate bill is Senate Bill 319. That's the cross file. So the amendment would be to conform to the House. So you'd be voting on a favorable with amendments.
All right, Senator Bailey.
House Bill 868.
House Bill 868 is a constitutional amendment that repeals the requirement that Howard County elect 3 orphans court judges and instead requires that the judges of the circuit court for Howard County sit as the orphans court. And it also includes corresponding statutory changes that are contingent on the passage of the constitutional amendment.
The circuit court judges have not taken, we haven't heard from them. And they're the ones who are going to have to now sit as orphans court judges. The word I'm getting from Montgomery County is that the judges hate having to sit as orphans court judges.
I would
And that's the
not,
problem. That's the problem. By the time they finally rotate and become an orphans court judge, they've forgotten everything about the orphans court, and they have to learn it all over again.
I wouldn't,
How much does it increase the caseload?
What?
How much does it increase their caseload?
It was very light.
Well, Josh is answering.
So the Howard County Orphans Court handled 844 cases in 2020 and 1,079 in fiscal 2021.
There is a personal problem between the Register of Wills and the orphans court judges. It's very apparent from the testimony.
There was 2 places, what is it, Hartford and, was it Baltimore?
Montgomery.
Montgomery.
Baltimore has orphans.
No.
No, there was 2,
Hartford and Montgomery, the judges of the circuit court serve as orphans court judges.
so there's 2 that have already abolished it. And then we also have a system where we've allowed some places, Baltimore County says you have to be a lawyer, we don't allow lay people. So we've got all these different standards which we've allowed. And so I just think it's a little late in the game to start picking and choosing which ones. Look, if it was my county, I wouldn't do it. I like the orphans court. I think it's a good thing. I think it helps people because you don't need a lawyer. It's very inexpensive. I just personally felt bad for those orphan court judges that were up there, but it's not my county, it's not my delegation, and I go make arguments all the time that you all may disagree with, but this is what my county wants to do, so I'm fine with it. Or I should say, I'm gonna vote for it.
Live again.
Correct. I would say move favorable on this.
seconded. You want to do a roll call? All right, so then we got 1 down. Okay. So the bill passes favorably.
So, House Bill 833 does a couple of things. It alters procedures that a law enforcement officer in court must follow when there is reason to believe that a child who has been detained is a victim of sex trafficking or a victim of human trafficking. It prohibits the criminal prosecution of a juvenile or a juvenile proceeding against a minor for a qualifying offense, a violation, or an offense under 31102 of the criminal law article, which is sex trafficking, if the minor committed the underlying act as a direct result of sex trafficking, and adds offenses to the list of qualifying offenses for which a person may file a motion to vacate judgment if the person's participation was a direct result of being a victim of human trafficking. Just a couple of, one technical thing to flag on this. In the bill, I'd spoken with a couple of different advocates on the language in the bill. In the provision, let me just get the page number for you. So the provision on page 6, line 21 provides that where there's a qualifying offense or a violation, and the court finds that it was the direct result of trafficking, it requires that the court dismiss the case if the court finds that the child was the victim of trafficking and committed the qualifying offense, violation, or offense under 31102 as a direct result of being the victim of trafficking. So what the advocates had indicated to me was that the intent wasn't that the entire case be dismissed. It was that those qualifying offenses or violations, or that offense under 31102 would be what would be dismissed. And there was some disagreement between different advocates, or different ideas of how to address that. The simplest one being to say that the court shall dismiss, instead of saying the case, say the court shall dismiss the qualifying offense, violation, or offense under 31102. And other advocates had sort of a more verbose way of doing that, but the idea was that it would apply to just those offenses, not the entire case.
Just the qualifying offense.
Correct.
Right, not the whole entire case.
If the amendment's adopted.
Right.
Qualified, correct? So if the case is one of those, if it's CDS, right? They come in with a possession of a controlled dangerous substance, correct?
Right, so.
And if they
as
come
a
in there
qualified-
and
right.
they go in, and the problem with the bill is this: if you come in with a CDS offense, nowhere else in Maryland law do we then set up a pre-hearing where, based on another, the defendant can come in and claim sex trafficking. And by the way, sex trafficking doesn't actually require a pimp or anything else. It just means that he or she was involved in prostitution. If he or she claims they are involved in prostitution, by a preponderance of the evidence, they can just get the CDS charge completely dismissed and it doesn't go forward. How the heck is the state going to disprove that? They can't. It's a terrible precedent. You pass this bill, you're being here every year with every set of psychological issues, spousal abuse, PTSD. The court can come in, then they have to find it. Mechanically, this is really bad to do this. No. We're talking about a legal precedent that allows you to bring in another alleged crime that doesn't even necessarily pertain to this. And if you claim you're a victim of that, the state cannot move forward on the next set of cases.
But this is all under the umbrella of human trafficking, right?
No, it is not. It is under sex offenses, and there does not even have to be a quote-unquote, what people would think, or pimp or whatever. You just have to be a prostitute to fall under the current law. It does not have to be human trafficking.
I understand.
Labor trafficking, and I think to what.
Just to clarify the federal definition of.
Right, so I think the question is sort of relevant to what is sex trafficking, and how is that defined? So sex trafficking means the recruitment, harboring, transportation, provision, obtaining, patronizing,
Right.
or soliciting of a child for the purpose of a commercial sex act.
A child.
Right, so right, you're correct. This is all like in the universe of minors.
Right.
Right. And I think sort of to the question of, did you?
Good.
Okay. Sort of to the question of, does there need to be a pimp or somebody instigating that? Based on the
By
definition.
of prostitution.
Well, so.
How do you
not-
be a prostitute without a John or a pimp?
So the John, yes, but the pimp.
But the point is this: if you're voluntarily prostituting yourself.
You're a child. You're a child.
The John becomes the pimp in this scenario. In that scenario,
Well, they're just
would be
the trafficker.
the trafficker. Sorry, whatever.
Or the trafficking victim would still be the
Child.
minor engaged in prostitution, definitionally.
Right.
Now, sort of along these lines, I've spoken with the advocates about whether that creates sort of a situation where, under the provisions of the bill saying that somebody couldn't be charged criminally or proceeded against as a juvenile, in one of these cases is the direct result of human trafficking. Because you're talking about it in the context of it being in the direct result of human trafficking, and this is definitionally trafficking, just a minor engaged in prostitution. So the answer seemed to be that you could. Now, I guess what the advocates had also indicated was that
you could prostitute yourself.
Right, and that it would qualify under the
Under federal
exemption.
law, too.
Well,
That's
at
the
least under
definition.
this, because of the definition. What the advocates had indicated was that, or at least one of them had indicated was that there were cases of survival sex, is the term that they used, that would apply where a person or a minor was engaged in prostitution, even without a pimp, but for the purpose of, securing a place to live or, having resources for food or things of that nature. So that seemed to be what the intent with, providing that, that exemption for or the immunity for prosecution or
Which
or
is current
proceeding.
law.
No.
Current law is vacant.
It's coming tomorrow.
That's with this, but because of the existing definition under current law, that's how this would work functionally. Right.
Senator Watson. Hold on. Sorry.
It's okay. I probably have more questions because I think that the bill, there's been a lot of work, and I'm not sure if I know the current state versus some other iterations of it. One, to Senator Huff's point, and I understand his point, oftentimes, we're taking something and putting it on the front end that generally would be used in a criminal or juvenile case as mitigation. So it's like, yeah, you did it, but it'll be mitigated by the fact that, you know, you were human trafficked or you had some other issues. Now we're taking it and putting it on the front end, and my thought process says that, you know, these human trafficking cases, part of the goal is to make sure that the trafficked person isn't harmed more by the criminal or juvenile system after they've already endured the horror of trafficking, and the belief that they wouldn't have done it voluntarily, they were coerced to doing it because of the trafficking situation. But there's nothing in here that requires them to reveal the trafficker or the operation of the trafficker. And usually, in order to deal with something like that, it was like you gotta give up something sort of to get something. And so I would think that would be somewhere in this, or some kind of requirement, because the whole goal of law enforcement is to eliminate the traffickers and stop their business. Not just to, so we wanna help the young people, but should we not also want to provide a mechanism to go after the traffickers? I hear you. I heard some talk. So am I missing something?
Under our current hey, I'm speaking right now, please, okay? Let's do this in an orderly manner, okay? I want to respond to Senator Carter's comments, okay? Yeah, you raised valid points, but I want to respond to that. Jamie, under our current vacatur law for human trafficking underlining offenses, you don't have to prove the trafficker, right? You don't have to prove that there is a trafficker, that only that the victim of human trafficking committed that underlying offense as a direct result of being trafficked. But you don't have to bring in the trafficker, right? Is that correct? No, I don't believe you do. So are you making a higher standard for child victims?
After you already had a conviction, and now we're saying, you know what, that shouldn't be a stand against you for the rest of your life because you did it because you were trafficked. There's already been a conviction. This is saying you can't even be charged.
No trial.
And that's okay, but I don't see in terms of public policy that it's robust enough. It just doesn't make a lot of sense to not say, like, you know, in exchange for information about the trafficking operation, we'll dismiss all of the charges. That's just, to me, public policy and good policy.
I think it's good public policy to be able to allow this, and don't you have, Jamie, have to prove by preponderance of evidence that the child was that victim of sex trafficking, and that committed it as a direct result of being trafficked?
Yeah, but the trafficker and the
By
traffic
preponderance of
operation
evidence?
goes unpursued, and the trafficking goes unabated because there's nothing being done.
That's not what the bill is about. We're trying to focus on the child victim.
Kinds of things that happen in the law all the time. You know, I think we might even address another bill that might come to us today or soon, where we're ostensibly listening to the word of someone, like someone gets arrested with some drugs, and they say, I got the drugs. You know, the police might say, well, you know, tell us the dealer, and we'll make you a dealer. We'll let you go. But it's in exchange for something else, and it's for the public policy reason is we don't really care that much about the little possessor. We want to get law enforcement to go after the people that are causing the problem. And so I'm just saying, like, I would think that that should be a consideration. You don't have to agree, you don't have to adopt it, but I'm saying that in my opinion, better public policy would do something along those lines.
Well, I think we have addressed that public policy because if you, we already have laws currently, I don't think they're strong enough though, that go after the actual trafficker, actually, and also a trafficker of a minor child. I believe it's a felony under current law, Jamie, right? So I think that would be a separate bill too, if you wanted to enhance the penalties of a trafficker of a child.
Say that, yep, the kid's trafficked, dismiss the case, coercion, not accountable, but there ought to be something that is a benefit to society in terms of trying to abate the trafficking operation that created the child or children's situation.
I could not agree with you more, but I think the whole purpose of this bill is to help the child victim get out of this situation, because this is actually a child who probably is the most vulnerable, most helpless, most voiceless, who probably was coerced into doing these qualifying offenses as a result of being trafficked, because they're very impressionable. They will do what their trafficker said, and they have to do it by preponderance of evidence. And this is to further, I'm still speaking, okay? This further prevent this child from a downward spiral. This is to help this child, uplift them out of this situation so they can get help, from a navigator, and then have the particular offense, the qualifying offense, dismissed so they can get on with their life. This is like, I know we've had a lot of laws dealing with helping juveniles be in the unfair spiral of an unfair criminal justice system. Well, this deals with an even more vulnerable victim.
Yeah, so I appreciate the discussion separating, well, not separating, trying to put together the protection of the child versus enforcement of the offender. But I kind of agree with the, Senator over there. But I thought, am I correct, there has to be a current coercive element associated with this for this bill to have teeth, right? It doesn't matter if a child was at one point trafficked or something, if they're no longer under that coercive body,
So
does this apply?
So when you say coercive body, Senator, are you?
When you use, so it sounded like Senator Huff was causing me to confuse sex trafficking and prostitution. Two different things in my mind. Trafficking, to me, implies a coercive element. There's someone forcing someone to do something that they don't want to do, and the bill seeks to hold them, make sure they're not held accountable for any crimes that are committed under that umbrella of coercion. Is that fair, the way I stated that?
So, I guess what's critical here is that, I guess you've highlighted a distinction between just prostitution by itself and sex trafficking.
Correct.
Definitionally, under current state law, because of how sex trafficking is defined, essentially the minor engaged in prostitution at all meets the definition of sex trafficking.
So that's why I was asking, can you read the definition again? Because it encompasses, you got two different concepts in your mind, but the definition encompasses both.
So, just pulling from the fiscal note, which tracks the current definition in 5701 of the Family Law article, sex trafficking means the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a child for the purpose of a commercial sex act. And I think what's sort of critical there is the words that would meet that definition are provision, obtaining, patronizing, or soliciting. So, some of that is sort of, I think, interwoven with prostitution itself. Somebody patronizing, that would be the John. And I guess arguably you could say that even absent, a pimp or an organizer, I guess you could say that the minor is providing, themselves as yeah.
Would the juvenile still have access to juvenile protective, not juvenile services? Some help, some remedies or anything, or they're absolved and they can go back on the street?
Sorry, I didn't catch that last part, Senator.
They are absolved of what the crime was, and they can just go back on the street with no help, no support, no infrastructure.
So no, what the bill provides for is that in these cases where the child is the suspected victim of human trafficking or sex trafficking, they are connected with a regional navigator, which is essentially a caseworker that connects the child with different services. So rehab, housing, things of that nature. That's what's contemplated there.
Okay, thank you.
Chris, you all right?
Yeah, I had a conversation with one of the advocates about sort of that scenario where if, you had a child who didn't want to avail themselves of those services, what would happen. And I guess the idea with that isn't stated in the bill, but, just sort of if the child was a runaway and just sort of absconded from receiving those services, they could conceivably be brought back into the juvenile system through a sentence proceeding, was the idea there.
But under this,
make. I mean, the point is this, that right now, I don't understand I think that for the criminal justice system, the mechanism that is setting up is bad, it's a bad precedent, but I also think the policy outcome is bad, because you're talking about a juvenile who will end up in juvenile services. That means they're not going to have a conviction that stays on their record. That means they're not going to stay in the system for their whole life. But it means that they will get services. It means that a judge and people will be overseeing them. I'm sorry, to send someone to social services and think that they're going to get a lot of help? I mean, have you all really dealt with a lot of, these caseworkers you get a lot of times are like college kids, people right out of college, versus our juvenile justice system where, they can actually have some accountability for them, especially if the kid came in on CDS charge. Like our drug courts and our criminal justice system is supposed to do a lot better helping people deal with drug problems than a social worker. And by the way, they can still get a social worker or any of those services, but remove them from the criminal justice system where there is at least someone overseeing them, an officer, supervision, a judge, the whole system is involved, and putting them out on the streets on their own and say, hey, there's a social worker, here's your card, good luck. How is that a better public outcome for a kid who's been human trafficking and has a drug problem? To give them a business card for a social worker, good luck. Versus using our whole DJS model, which is built around evidence-based practices, the whole system we built to help children, a rehabilitative model, versus giving them a card and telling them good luck. That is not a good policy outcome for one of these young people. So this is bad criminal law, terrible precedent, and the policy outcome is really bad.
The main point of this bill is to provide a safety umbrella for people these are children who are victims, and they are engaged in this crime, as the bill says, as a direct result of human trafficking. So while I totally agree with what Jill is saying, we cannot expect children to cooperate with law enforcement if they aren't given some protection in order to be able to do this. So all of the horrors that Senator Huff just mentioned are all a direct result of human trafficking, and that is in the bill. And so unless you're providing them with some measure of safety, they're not going to be able to get the help that they need from the regional navigators or the protection that they need in order to be able to cooperate with law enforcement in order to get the trafficker. That is the core of what this bill is about. 40 other states have done this. Maryland is lagging tremendously in providing protections to victims. They are victims of human traffic, and they're children. They are children. I also would like to add that the state's attorneys support this. I don't think the state's attorneys would support this if they felt like we were letting, criminals off the hook. I think this is a really important.
It's not necessarily just criminals off the hook. Kids are not going to get services.
I think
You're
that
removing
is
them from DJS and you're removing them from the system.
System, right? We are slow, but we're getting there where we're putting in place the infrastructure in order to be able to help victims of human trafficking. I hear what you're saying. I don't want them to be just sort of out in the world, but I don't want them to be in jail because I don't think that that's what we want victims of human trafficking to be.
They're not ending up in jail.
I want them to be able to, as a direct result of human trafficking, not to be prosecuted for these other issues.
Here, I've got one question though, because this, and I think we should vote on this, or we should get this information before we vote on it. We have spent so many years doing work on this stuff, on vacatures, on affirmative defense, and the amount of hours and time. I would like to know before we add on to it, how many times vacatures and how many times affirmative defenses have been used? The current law. And then we're going to go to testing.
Yeah, I don't currently have that information, Senator, but sure. Yeah, I'll go ahead and reach out to the States Attorneys Association about that to see if they have it.
Senator Cassidy.
Yeah, so my understanding of this bill is that if a 17-year-old is charged with prostitution or driving with uninsured or driving without a driver's license or suspended driver's license or failure to display a registration or prostitution or indecent exposure or theft, trespass, malicious destruction of property, et cetera, if they're charged with one of those, they can, in the normal system, they would come in and be put in the juvenile justice system, and they would have their hearing and evidentiary, and they get all the services they need. Under this law, all those charges, what would happen is if they come in and they file a plea that says, I was engaged in prostitution, then 15 days later you have a hearing at which they come in and say, yeah, this was because of prostitution, and the state said, and they say to the state, can you, I'm sorry, this is, I'm involved in prostitution, and that's why I did this, and the state would say, we don't know one way or another. We have no idea. We just got this case. We pulled the kid over because he's driving without a license or he's destroying property. I don't know anything about this prostitution stuff. They weren't doing prostitution when we were there, so I have no idea. But 15 days later, he comes before the court and says, yeah, I was involved in prostitution. And now the court has to just dismiss the charges. They dismiss the case. The case is gone. There is no case. And they refer him to one of these social workers, and it's gone. We have no idea whether that kid has been cared for, whether they have a drug problem, a mental health problem. And society has no idea what their problems are. They're just off with this social worker. We've lost faith. We have no contact. They're gone. And whatever services they need, we have no idea if they're going to get them at all.
DHS knows.
No, they don't, because you prefer the regional. But if they don't go to the regional navigator, there is no repercussions. They just leave.
The criminal justice system is better.
Well, remember, it's the Department of Juvenile Services, and we've repeatedly said in this body that the Department of Juvenile Services is different. It's not part of the criminal justice system. It's the Department of Juvenile Services. We even renamed it we said Department of Juvenile Services. Their whole focus is, okay, we've got this kid. They come at trial. We have a trial. Yes, you did in fact drive without a license. You don't have a license. You got to stop driving without a license. But now you've brought in that, hey, yeah, but the reason is, listen, I'm engaged in prostitution. I'm a victim here. At which point the court can say, all right, listen, we're going to put you in the juvenile system here. We're going to get you the services you need. We're going to watch you. We're going to find out where.
We've set up here. We haven't done DJS from, we made a decision way back when that we were gonna do regional navigators, not DJS.
Well, this becomes ludicrous because you've basically, anybody who comes in and just pleads they're involved in prostitution, the state can't refute that. They have no knowledge, and they all just disappear. And they have these regional navigators, which we have no control over. And yeah, there's no way to refute it. And so these people just disappear in the system. I don't understand the fear that we've got. We just finished doing all kind of bills in here to change Department of Juvenile Services to make it much more kid-friendly across the board. And now we're sort of running away from that and saying, we don't want to put kids into that. I'm like, these are precisely the kids I do want to do Department of Juvenile Services. These are people who clearly have a problem, and let's use DJS what the hell it's supposed to be used for, which is identifying kids' problem and getting them the treatment, the services they need. And we can monitor that. We can make sure they're getting them. There's a difference between knowing they're getting the services and pretending they're getting the services. Under this bill, we're just going to pretend. It's out of sight, out of mind. That's what this bill proposes.
Okay, let me tell you a little bit of institutional background with this particular bill. It was a work product from the work group on child victims of human trafficking that was led by our wonderful current Secretary of State, John Wobensmith, and composed of members who actually deal with this on an everyday basis. And what came out of this bill was a consensus. And this year, for the first time, we had a total consensus from all the stakeholders, including the state's attorneys and law enforcement and advocates. And our focus was to uplift a child victim of trafficking who did any qualifying offense that is listed in here that was the direct result of being trafficked. And our purpose is to help these children get out of this downward spiral and avoid having to go through the even the juvenile justice system, and be protected and be directed. According to the bill, they have to be directed once the law enforcement suspects that they've been a victim of sex trafficking. They have to direct them to a regional navigator. Now, you remember I think it was 2019, we passed a bill to create a regional navigator program, which would provide support and guidance to victims of trafficking, and particularly kid victims, which most victims are kid victims. And this bill just would align Maryland with 42 other states, not just 40, but 42 other states, in doing something to help child victims. And as we had said before, it has to be a qualifying offense, just like when we passed the vacatur bill, we list a bunch of qualifying offenses. And it has to be, the judge has to find, or the court has to find, by preponderance of evidence, that the child committed that qualifying offense as a direct result of being trafficked. So that's all it does. And I think it's a good public policy to help these kids get out of a very terrible situation. They're very impressionable. They sometimes don't know where to look. They may have run away. They may have had troubles at home, or they may have been abducted. This is just very deplorable situations that they're in. So this just helps the child victim. That's all I gotta say.
I just want to comment with regard to the concerns about not connecting with juvenile services. And I don't pretend to be an expert in this, and I wasn't involved when all of these different infrastructure systems were created. But there was a policy decision made at some point not to go the DJS route with regard to human trafficking, right? And that's why the system of these regional navigators within the family law article was set up specifically for youth victims of sex trafficking. And so we can have this discussion about them, meeting with, and I don't dismiss meeting with social workers, because I think these are kids and this is probably what they need at this point. But for whatever reasons, we made specifically policy decisions not to go the DJS route and to create a different route and a more holistic, supportive route, specifically for this kind of matter, because it is particularly insidious, and because it involves children, and because it involves some measure of losing some ability to be able to control one's own destiny and autonomy. And so I'm okay with that in this instance. And I think they should be supported, but I think that's what the regional navigator system is set up to do.
Thank you, Mr. Chair. So I think the fact that the state's attorneys have withdrawn their opposition to this bill is significant. But on the other hand, I want to talk about the conversation essentially between Senator Lee and Senator Hedelman. At the same time that the John Wilbon-Smith's commission was studying abused minors, there was another commission that Will Smith and Joe Carter and I were on, studying the juvenile justice system. And that resulted in the bill we passed this session, which fundamentally transforms the juvenile justice system and puts the emphasis on treatment of juveniles rather than confinement. The sum and substance of what we did when we passed that was to replace a system which is always focused on committed facilities with a system which instead focuses on treatment in place. So the Wilbon-Smith Commission was coming up with recommendations based on the system in place at that time. We now have a new reformed juvenile justice system, and now I hearken back to what Senator Huff said. Seems to me that based on the new system, which emphasizes treatment, it's better for girls, minors, maybe some boys, who fall into this category to be treated by the juvenile justice system that we now have in place as reformed, rather than just give them a card and say, talk to some regional navigator. I don't know much about the regional navigator system. I've never heard about it until this afternoon. So that's sort of where I'm coming down.
Program was created in legislation that we all passed, and you were here too, and I believe it was 2019. Is that correct, Jamie? And it was to provide services and guidance to the victims of, specifically victims of trafficking. And so I think that in this bill, law enforcement's supposed to refer the child victim to a navigator, and a navigator services, regional navigator that are specifically designed to help a trafficking victim, particularly a child victim of trafficking.
If we're going to vote on it, I'll speak on it.
I don't think we're ready to go out of it.
Okay, I'll wait.
More point, which is actually a really good point. We're not talking, I don't mean to, sorry, no, sorry, an important point, not a good point. Important point is, this is not about treatment and rehab. This is about protection. So these are people who are being abused. And so it is about, I mean, isn't that the name of the bill, Safe Harbor? It's about protecting. It is not necessarily about linking them with therapy. It is about providing protection because they're being abused.
How does it protect them?
It removes them from being a criminal.
It's not a criminal system, it's a rehabilitative system.
I'm not talking about DJS. I'm talking about removing them
But you're
from
not,
the
when you're put out
process.
on the street with a business card, you're not protected. When you're within the system, within our system with judges and parole officers and juvenile justice, when you're in that system, there is some protection, oversight, and accountability. When you're a kid that has been trafficked, that means you've been taken from your parents. There's nobody out there for you whatsoever. And we're going to count on this regional coordinator, regional whatever person to provide the protection?
It's not a person, it is a system. I mean, it is a system and it is an
It ain't-
infrastructure of services.
It ain't funded to the tune of DJS.
Let's do this. Can we get the annual report? Because under the Regional Navigators Program, there's an annual report issued. And I've never seen one of those. It'd be interesting to see what the Regional Navigators Program is doing.
Thank you, Mr. Chairman. And I just wanted to join Senator Lee in providing some kind of historical context and where this bill comes from. So this is lots of old-timer talk. I apologize for it. But when I came to Annapolis, there was no statute criminalizing the trafficking of children for sex, for labor, or anybody, to be honest. There was a pimping statute, but it wasn't particularly applicable to what the behavior was, the wrongful behavior that we saw. And so I joined with Senator Lee, who was then on Judiciary, and we passed Maryland's first, I'm sorry, Senator Huff was there. And Senator, I'm sorry. I didn't mean to exclude anyone. I was just, no, fair enough. I'm just kind of going through the history, and we passed Maryland's first law criminalizing sex trafficking, including sex trafficking of children. But we realized, even though we were dealing with the perpetrators of this and criminalizing terrible behavior, that we needed to do something on the victim side. And the first thing that we did, in my recollection, is we provided an affirmative defense. We said, if you are a victim of human trafficking, you can provide that information as an affirmative defense to a charge. And it kind of went hand in hand with what was already existing law, which was the defense of duress, the affirmative defense of duress. And as long as you indicated to the state's attorney that you intended to have an affirmative defense as your defense at trial, you could offer this at trial, and as long as you proved it by a preponderance of evidence, you would be found not guilty of that. And then we took it a step further, because we knew that some people had been convicted prior to our authorizing that affirmative defense. And so 4 years ago, we sat in this committee, many of you were here, to provide vacature. So post-trial and post-conviction, if you were the victim of human trafficking, you could apply to have that conviction vacated if it was in the interest of justice, and if the behavior was directly related to your victimhood as a victim of child sex trafficking, or any sex trafficking, to be honest. This is the next logical leap from that bill and everything we've done. This takes, as Senator Carter mentioned, takes what we created 4 years ago on the back end and moves it to a more equitable place on the front end. I recognize that it's a novel thing to do, but it is not an inconsistent thing to do with what we've already passed. Instead of someone going through the process, obtaining a conviction. Now, I understand in the juvenile justice system, it's not technically a conviction, it's a finding of liability. But nonetheless, we then take that hearing and essentially move it towards the front end so that people don't have to go through that trial at all. And for me, that makes sense. For me, that's a logical conclusion to everything we've done up till now. And so when this comes to vote, if this comes to vote, I'm going to vote in favor of the bill.
All of our good work that was just reiterated, how it's being used, and then let's come back and look at that.
I'll wait.
Hold it.
While we're looking at, I wondered whether, I'm looking at the bill. The bill requires that in one of these situations, the youth should be referred to a regional navigator, but there's nothing in here about what happens if the youth fails to keep appointments, submit to the services that the navigator provides, unlike in the juvenile justice system where there are consequences if the person fails to adhere to the protocols. So maybe somebody who knows something about the regional navigator system could, like Jamie, could provide us with some information about what happens if someone who's referred to a regional navigator doesn't show up and just goes right back to the streets.
So I asked that question to one of the advocates on the bill, and I think the idea with this is that the SENS process would take care of that. Now, I think the child in need of supervision process would take care of that, right. That was just the feedback from one of the advocates. I don't have any more information than that.
All right. All right, House Bill 211. Tell
House Bill 211 authorizes a police officer to arrest a person without a warrant if the officer has probable cause to believe that the person is knowingly being a participant in a straw purchase of a regulated firearm under Section 5-141 of the Public Safety Article. There are provisions in state law governing the circumstances under which a police officer is authorized to make a warrantless arrest. One of those circumstances that's applicable to the provision of the bill that's being modified, or provision of statute being modified, is that a police officer may arrest without a warrant if the officer has probable cause to believe that the person has committed one of those enumerated offenses specified in statute, and that unless the person is arrested immediately, the person may not be apprehended, may cause physical injury or property damage to another, or may tamper with, dispose of, or destroy evidence. So that's the provision of law that's being altered with the bill.
So they removed in the House the part that actually enhanced the penalty for straw purchases, correct?
Right, so the language that was originally included
Made it a
was
felony.
that it was made a felony. Now, the actual penalty wasn't altered.
Penalty's not moved, which I find interesting because the only committee testimony that I saw in here was Baltimore City, and the only thing they wanted was the enhanced penalty. So the bill doesn't do that, and the bill goes to warrantless arrest. There's a reason why in our country we require warrants for arrest. That's like a pretty big deal. You know, that's like the founding of America type deal, that we don't go around doing a bunch of warrantless arrests. And if you look at a police officer can already do a warrantless arrest on a straw purchase if they witness it happening in front of them. So if they're out in front of a gun store and they see it, by the way, straw purchases are not prosecuted very often. They're hard to prosecute. So even the effectiveness of this, I don't know, because if they see it now, you can do a warrantless arrest. But outside of that, most of the crimes, the small exemption that we allow warrantless arrest for are things that, like wear and carry. So they literally see you and you've got the gun on you right then in your person. Or they see you selling drugs right in front of them. But I just think the idea of, I generally think, and there's usually bills in every year to go to expand warrantless arrest. I think that's a bad idea. I have a real problem with that. If they see a straw purchase in front of them, they can already do it. But what are you going to have? Police officers just barging in people's houses, like, you know, now on dealing with their property and guns they purchased and stuff, and start arresting people? That's why you have judges. That's why you have warrants. That's why you have the criminal justice system work like it is.
I tend to agree with Senator Huff with these warrantless arrests. The other concern that I have, and I've been trying to just get some clarity on, is how we're using the term participant, and whether or not that particular term, I'm assuming it goes beyond the dealer, and it goes beyond the straw purchaser. So I would say that even that language around who a participant is likely would need to be tightened up. I would hate someone, I guess, just being involved in some sort of a conversation if somebody wants to purchase a gun and the third party says, well, you can buy it from person A. Now the person who told you to buy from person A, are they then caught up because they are a part of this whole straw purchase? I mean, I think we need to be careful there as well, but like I said, I agree with Senator Huff's comments.